webinar.
Welcome everyone to our webinar today, the ADA in Jails and Prisons, a guide to accommodating inmates and visitors with disabilities. Our presenter today is Julie Ballinger. In just a moment I'll hand it over to her to introduce herself. Before I do that though, I just want to remind everyone there will be questions and answers at the end of this webinar. So as you're listening, you can use the chat box to submit questions and comments, and I will read those to Julie toward the end, and she'll be able to answer you. So Julie, I'll hand it over to you.
Thank you, Caleb. Good afternoon. I hope everyone is doing well. First of all, I want to thank the Mid-Atlantic ADA Center for the privilege of presenting today on behalf of myself as well as the Southwest ADA Center. It's always a privilege when one ADA Center can work with another ADA Center, so thank you. Just very quickly, a little bit about me. I have been in the disability rights field for over 32 years. I have worked with the Southwest ADA Center for, oh my goodness, over 20 years at this point. The Southwest ADA Center, we serve what's called Region 6, which consists of New Mexico, Texas, Arkansas, Oklahoma, and Louisiana. Okay, let's just move forward. Before we jump into the guide, let's look at just a few statistics. We know that more than 750,000 people with disabilities are incarcerated across the nation. These inmates can, if the facility does not comply fully with the ADA and implement ADA best practices, we know that these inmates can serve harder time with less access to positive programs such as early release programs and vital services. We have found that due to discriminatory practices, inmates with disabilities can end up living in a prison within a prison, and we'll talk more about that as we look at the guide. Additionally, we know that approximately 85% of incarcerated youth have a disability, and not surprisingly, often undiagnosed. They are referred to the juvenile justice system earlier than youth without disabilities, and they are referred for a greater number of serious crimes and experience shorter survival rates before they recidivate. Slide 12, thank you. Finally, we know that facility visitors with disabilities often face barriers including a lack of accessible parking, inaccessible entrances and visitation areas, lack of effective communication, or a modification of policy that would make the facility accessible to that visitors. Correctional facilities also don't necessarily inform visitors of their ADA rights and do not always have an ADA grievance process for visitors with disabilities. And we'll also refer to that later as we go through the guide. So as we advance to slide 13, the corrections guide. In response, the Southwest ADA Center's Disability-Related Access for Inmate and Visitors Guide is designed specifically to be utilized by corrections to educate and train facility staff regarding their ADA responsibilities concerning inmates and visitors with disabilities. Moving on to the next slide, which is slide 14. You can download our guide. I know that when you registered, the Mid-Atlantic ADA Center sent you this link, and it's also here in the PowerPoint. The guide is called Americans with Disabilities Act, Disability-Related Access for Inmate and Visitors Guide, and there's the link in which you can get to it. It's available in HTML and fully accessible PDF. Just a note here that this guide will be published on the ADA National Network, hopefully within the next 2 or 3 months. There will be some slight revisions to the guide as it gets posted to the website, but there's no changes to the guide in terms of content. So now let's examine the comprehensive guide and consider how it can be utilized within the correctional system. And I know that Maynard is pulling it up. So you all should have in front of you the guide itself. Okay, so I just want to say that Caleb and Maynard at the Mid-Atlantic ADA Center has been wonderful in working with me to be able to get the guide on your screen and to be able to scroll down the guide as I refer to it. So thank you, guys. I really appreciate you working with me to do that. All right, so let's go ahead and scroll down to the table of contents. Okay. Now, as we jump into the guide, I just want to say that due to our time constraint, I'm obviously not going to be able to discuss every single part of the guide. So I'm going to be cherry picking throughout the guide in terms of just stressing some sections and not stressing some other sections. So bear with me, and you will see by the end of our training today, but you will see how the whole guide looks like and how it plays out. I do want to stress that I am not an expert in corrections. I'm an expert in the Americans with Disabilities Act. What I'm very good at is taking any sort of situation and applying the ADA and working with that entity to figure out best practices. As a matter of fact, that's really, in many ways, what the regional ADA centers do. We're actually quite good at that. So let's look at the table of contents, and I'm just going to simply read down to show what the guide contains. We have the introduction, Americans with Disabilities Act. Disability civil rights do apply to correctional institutions. Who is protected under the ADA? Qualified individual with a disability. Designated person who assures compliance. The ADA grievance process, notice of rights, filing of an ADA complaint. Policies and procedures equals access. Limitation on state and local government obligations. Direct threat. Integrated settings priority. Program access. Architectural and transportation access. Policy modification. Effective communication. Other general requirements. We're going to look at service animals, mobility devices, other power-driven mobility devices, common access complaints by inmates and visitors, conclusion, and then there are resources included within the guide. So if we could scroll forward. So as you can see, this is a very extensive guide that covers all aspects. So we're going to pass where it says guide purpose, and we're going to go to the next page, which is page 1 in the introduction. As we scroll down to the introduction, I just want to point out in one of the paragraphs that according to John Wadach, the head of the Disability Rights section of the U.S. Department of Justice Civil Rights Division, from its inception from 1995 to 2011, the majority of the thousands of annual complaints the office received from inmates with disabilities, actually nearly all of them were substantiated. So that is something to take note, something in terms of why prisons need to be proactive in terms of their compliance with the ADA. If we could scroll forward to page 2. So you'll see at the top of page 2 is simply information of what the ADA covers. What this guide covers is Title II, State and Local Government, which gives people with disabilities the equal opportunity to benefit from all programs and services and activities. So we're going to scroll on down to the Disability Civil Rights Apply to Correctional Institutions. Really, what this section talks about is, indeed, correctional institutions are not only covered by Title II of the Americans with Disabilities Act, but if the institution receives any federal funding, it has to comply with Section 504 of the Rehabilitation Act. This is not only true in terms of the civil rights of inmates, but also the civil rights of visitors to the facilities or any programs related to the facilities. If we could move forward to page 3 at the top. I do want to point out and note here that government-funded private correctional institutions are obligated to carry out the government's Title II and Section 504 obligations. I know that many states, state governments contract with private entities in terms of prisons, and it's very important that these state entities make sure in their contract with these private prisons that the civil rights of inmates and visitors are honored. At the bottom there where it says therefore, I think this is important. Therefore, it is imperative that all facility staff, including administrators, correctional treatment specialists, compliance officers, medical and other staff should have a functioning knowledge of the ADA requirements as it pertains to the institution. Basic ADA information must be included in correctional officer and other staff training, especially in their first year of employment. Hence, here's the guide. We're hoping that you all can utilize this guide to make that happen. If we go down a little bit further where we are now, who's protected under the ADA, clearly that section will cover that in terms of a physical or mental impairment that substantially limits one or more major life activities. A record of such an impairment, we'll scroll on to page 4. Regarded as having such an impairment, etc. The reason I included this section as we scroll on down on this page is that there are individuals not covered by the ADA. And given that this is a correctional institution setting, it is important that they are aware that there are certain disabilities that are not covered, such as pedophilia. As we go on down on page 4, which says determining who is covered, we all know that disabilities can include chronic illness, physical disabilities, hearing and visual impairment, psychiatric conditions, intellectual development disabilities, etc. And so we encourage that a best practice is to have trained and supervised corrections staff, including correctional treatment specialists, conduct screening interviews of all inmates upon admission so that the institution can identify those inmates with disabilities. And once you're able to do that, then you're able to follow up in terms of best practices and policy modification, accommodations, effective communications, etc. It's also important to note and follow up with inmates that they may develop disabilities and medical conditions during incarceration, and then at that point we'll have ADA rights. Let's scroll on to the next page, page 5. Let's talk about qualified individuals with disabilities. According to the ADA and Section 504, qualified inmates with disabilities absolutely should have access to all programs to which they would otherwise be entitled, whether mandatory or voluntary. Correctional institutions must ensure that qualified inmates with disabilities should not be excluded in participating in any of these programs, denied benefits of these programs simply because these programs and services are inaccessible or unusable by individuals or a particular individual with a disability. So it is imperative that correctional facilities develop non-discriminatory eligibility criteria for early release, parole, and other reentry programs, as well as programs that afford earned time of early release. So a qualified individual with a disability is a person who can meet the essential eligibility requirements of the program with, if needed, reasonable modifications to rules, policies, practices, and or with the removal of architectural, communication, or transportation barrier. So we're going to talk more about this when we get to the section of program access. So if we can scroll down to the bottom of page 5, designated person who assures compliance. I think many of us are very familiar now, almost 30 years after the ADA has been passed, that the government entity, including correctional institutions, must appoint one or more designated persons to assure compliance with Section 504 and the ADA. The ADA coordinator has to be the one, doesn't have to be, but could be the one who could investigate complaints, who can be involved in determining reasonable modifications, determining effective communication, for both prisoners and inmates. How the correctional, let's go to the next page, how the correctional institution wants to express that compliance. They can have one person, they can have several people, they can have an ADA coordinator for visitors, they can have an ADA coordinator for inmates. I think the real point here is that the ADA coordinator has the time, enough of their job, if it's not a full-time job, enough of their job where they are able to, in an efficient manner, address ADA issues. Correctional institutions certainly can use their compliance officers that are already working towards compliance of other laws, but again, I would just like to stress that the ADA coordinator should be able to devote enough of their job to adequately address ADA issues within the institution. If we go, let's see, where are we? It's a best practice for the institute. It is a best practice which is actually promoted by the ACA, and I know many of you, if you're from and representing a correctional institution, the American Correctional Association, and this comes directly out of their institutional standards, and it basically says that the ADA 504 coordinator should develop relationships with and use the expertise of institutional staff, advocacy groups, nonprofit organizations, agencies of government, and others that have relevant knowledge and experience. And so I think this is one of the keys for an institution to become compliant with the ADA. Okay, I'm gonna pause just a minute here. Okay, so now we're on page 6. So what are those organizations? They can be your state's disability rights organization, they can be centers for independent living, and certainly I would encourage you to develop a relationship with your regional ADA center. Okay, so now we're on ADA grievance process, notice of rights, filing of an ADA complaint on page 6. I'm just going to spend a little bit of time on this. Obviously, the institution must have a ADA grievance process, not only for the inmate, but for visitors. The institution can incorporate an ADA grievance process in their existent grievance processes, except make sure that if you do this, the ADA grievance process requirements are met. So if the institution has a grievance process that takes 100 days to resolve, that's not going to meet the ADA grievance process requirements. So you need to look at that as you either review or develop your grievance processes. Again, a grievance process must be available to the visitor. Notice of rights to the inmates and the visitors must take place. It must be widely publicized in that in visitors' areas throughout the institution for the inmates, etc. Just where it can be publicly seen either by the inmates or the visitors. Websites, absolutely. Make sure notice of rights and how someone can grieve what they believe to be an ADA violation of their rights should be posted on the website. In terms of filing a complaint, inmates can file a complaint with U.S. Department of Justice, which actually we referred to earlier in the introduction, or they can bring a private lawsuit. However, the Prison Litigation Reform Act will come into play there, and if the institution is housing a federal prisoner, then the U.S. Department of Justice's Administrative Remedy Program will also come into play. It is important to make that point because many state or even local institutions will house federal prisoners, and so it's important that those federal prisoners, those federal inmates, are afforded that process. Let's go to the next page, page 7. And we're going to go down to policies and procedures equals access. All right. I hope y'all are doing okay. This is a lot of information. And I can't tell you how much I appreciate you all bearing with me. I know the goal today is just to show you that this is a chock full of information guide, that it does cover what it needs to cover, and we do hope that you will find this guide useful. So under policies and procedures equals access. For inmates with disabilities, it really is a best practice to develop detailed policy and procedures on how an inmate can request an accommodation and how the corrections facility will proceed with that request. You can obviously develop accommodation request forms and then procedures on how it's filled out and where it goes. The ADA coordinator should most likely be involved in this process, etc. I have found when I just do a random review of institutions in any state, I find, unfortunately, more often than not, that when it's posted on that institution's website, a review of the inmates' rules and policies, there's no mention that inmates with disabilities have the right to make an accommodation request under the ADA and possibly Section 504. So in order to determine if an effective accommodation should be provided, the facility, where appropriate, can review the inmate's medical records, arrange to have the inmate diagnosed by appropriate professionals, interview staff, and take other actions reasonably necessary. You should always engage in the interactive process, and the interactive process with the inmate or the visitor is an informal, flexible conversation to determine the appropriate accommodation to remove the disability-related barrier. Just want to make a note here that the interactive process is not really a polite thing to do. It is actually a legal requirement in which you must do in terms of talking to the inmate, talking to the visitor of where is that disability-related barrier, what kind of options can happen to remove that barrier so that the inmate or the visitor can have equal opportunity to participate. In doing this, a promising practice could include a partnership with an inmate's case manager, the ADA 504 coordinator, and if appropriate, medical staff. And I emphasize that because once an inmate has been identified and their disability has been identified, and hopefully in the intake process and the admission process, a lot of that has happened. Medical examinations throughout the years that has gone on and has happened, is that once disability information is established, that if, for example, an inmate who's deaf needs an ASL interpreter, that does not have to be run back through with medical staff. That's just actual common sense. Let's go to the next page, which is page 8. There you can see case law, Pierce versus the District of Columbia. And really what this is about, which I think is very important to note, is that usually under Title II, a public member needs to indicate in some way that they need a modification of policy, effective communication, so that the Title II entity can respond to that. But this is really a higher calling, more stringent, in other words, in which correctional facilities need to do. And it basically says that prison officials have the duty to assess the potential accommodation needs of inmates with known disabilities. That is a step up. It's an anticipation. You know the inmate, you know their disabilities, and it's expected that there is some anticipation that not only will they need accommodations, but what accommodations they may need in relation to whatever program or service that they're involved in. So whether or not the person makes a specific request, again, the institution is expected to take on a proactive role. With visitors with disabilities, officials should develop policies and procedures that apply to members of the public who enter into the department facility or participates in the department, any other sponsored program, services, or activities. There should be directives and procedures how to assure a visitor's access through policy modification, effective communication, or physical barrier removal. Clearly state for the visitor the steps that they need to take to make that request, and of course, as we talked about earlier, engage in that interactive process with the visitor. You want to make sure that the visitor is aware, again, as we talked about earlier, that they do have a right to grieve if they feel that their civil rights have been violated, and how they grieve should not be a complicated procedure for the visitor. And in terms of notifying the visitor that they have a right to request accommodations, modifications, effective communications, they have a right to grieve, it should be easily seen by the visitor, not buried in the mounds of paperwork in which they may have to do to be allowed into the facility. Again, just to stress, when I look through various states and correctional institutions and their websites, I see postings for visitors, I see the policy, I see the rules they must follow, but I don't see a line that says, if you need a disability-related accommodation, here's how you get it. As we go down to limitation on state and local government obligations, still on page 8. The correctional entity is not required to provide program access if it would result in a fundamental alteration in the nature of the program or an undue financial or administrative burden. Let's talk about that. Weighing civil rights versus undue burden. Let's keep in mind that in some circumstances, the lack of disability access could result in significant detrimental harm to the inmate. An example could be refusing to modify a policy that will allow the provision of a specialized mattress for an inmate with paralysis to help prevent skin pressure ulcers. Or another example is an inmate who, due to deafness, has limited reading abilities, is subject to multiple disciplinary actions because they're unaware of the standards for acceptable behavior due to being denied a qualified sign language interpreter. Or they didn't understand the information contained within the Offender's Orientation Handbook. The next page, which is page 9. Let's look at the direct threat section of that. Obviously, security is the prime concern for facility officials, and that if it's objectively determined that a person with a disability is truly a direct threat that cannot be mitigated, then yes, that person may be excluded from participation in a service or program. Under the ADA, though, a direct threat is defined as a significant risk to the health or safety of others that cannot be mitigated or eliminated by a modification of policies, practices, or procedures, including accommodations, or the provision of auxiliary aids or services, effective communication. And we're going to talk more about this as we look at modification of policy and effective communication. Obviously, the correctional institution can have legitimate safety requirements based on actual risks and facts. As we go down to integrated settings priority, basically, and we're still on page 9. Basically, correctional institutions need to house individuals with disabilities in the most appropriate setting. And the priority of that is the integrated setting. It's vital to establish facility correctional standards that include classification and placement procedures that generally place inmates with disabilities in facilities offering the same programs and opportunities as afforded to prisoners without disability. Therefore, the programs and services must be accessible to inmates with disabilities. In other words, if you transfer an inmate to a more architecturally accessible facility because the inmate needs that accessibility, but that institution offers far less programming or services or sentence reduction credits, that could be a problem under the ADA. In terms of the use of segregation or solitary housing, that has to be very carefully scrutinized, even if you are placing that inmate in that type of housing for their own safety. And so there's a lot of discussion to be had around that, and again, I think it's important that the ADA coordinator be involved in all of those. The next page, which is page 10, let's go ahead and go down to separate programs. And an institution certainly can have separate programs that benefit inmates with disabilities, but just keep in mind that you can't say to an inmate, this is your program, you cannot participate in the regular or quote-unquote normal programs That is something that is a violation of civil rights. If the inmate wants to participate in those regular programs, again, program access comes into play through modification of policies, effective communication, architectural barrier removal. If the only way to provide the service to the inmate is has to be a separate program, it really should be the option of last resort. Okay, on page 10 still, let's look at program access. A facility, when viewed in its entirety, must be readily accessible to and usable by inmates and visitors with disabilities. Program accessibility may be achieved by a number of methods with integration priority, and again, that's policy modification accommodations, effective communications, including an accessible website for visitors with disabilities, and architectural access. So as you can see, there are examples of the programs. Let's go to page 11 and look at creative program access on page 11. Okay, very clearly, creative program access solutions may have to happen for programs within the institutions. In looking at what programs in terms of work programs, other kind of programs, many of these programs are require physical activity. And many of these programs, an inmate can earn release program. They can earn sentence reduction credits. And so the institution needs to look at, okay, this program is very physically based, but how can we figure out, be creative around how we can expand this program in some way where this inmate with this particular disability can participate in this program, such as conservation projects of wildland fire suppression, flood, other emergency responses, maintenance of public lands, manual tolling of farms. These obviously require specific eligibility qualifications. Inmates can earn the right to participate by their nonviolent behavior and by following and conforming to the rules, but they have to also be physically fit, carefully screened, and medically cleared. And so it's coming forth and saying, all right, let's be creative here so other inmates with disabilities can participate. They meet the behavioral criteria, but they may not meet the physical standards due to disability. The facility should explore possible program expansion to include components and responsibilities such as administrative or sign-line support work, filling out reports and paperwork, coordinating teamwork, inventory of, sorting picked crops, food preparation, and on-site meal services, etc. Obviously, the goal here is the equal opportunity to earn either the pay or the early release time. I do want to make a note here that is not in the guide, is that I know that many institutions define a full workday as 8 hours. In terms of a modification of policy, if you have an inmate that due to disability is unable to work that full 8 hours, there could be a policy consideration that 6 hours is a full day, which then they earn the early release credits equal to that of the 8 hours or pay, etc. Again, I realize that some of this takes some discussion and understanding and consideration, and I would highly encourage that your ADA coordinator be involved, be well trained in the ADA, as well as the ACA states, that you involve advocates, other sorts of nonprofits, other organizations in the community that can help you figure out some very creative solutions, as well as your regional ADA center. Let's go ahead and just simply look at services provided by kiosks. I'm not going to really cover this. Just suffice to say that I know that many institutions are now making use of kiosks, and so you need to make sure that they're accessible, and this section talks about that. Let's go to page 12, down to architectural and transportation access. In terms of architectural access, I'm not going to really talk about that. There are good resources in this section, as well as good resources at the end of the guide. Let's go to page 13, to transportation access. Obviously, standard transport practices can be dangerous for inmates with mobility disabilities, and so institutions need to be thinking and accommodating that. Inmates can be at high risk of unintentional injury when being transferred and seated in a vehicle that is not accessible to them. And so it is important that the system, the correctional system, is aware and has a means of accessible transportation for inmates who need it. That includes that if the inmate has an off-site program, such as an off-site work program, that the inmate should be able to participate in that off-site program and should not be held back because there is no accessible transportation that the facility can provide to take them to that. And so really the answer is that the correctional system is aware that they need to have accessible transportation. If we look at Clements versus Dart on the same page, page 13, this is really, again, about program access. As you notice that part of the format that I do in the guide is that I talk about the topic and then I end it with what the courts are saying about that topic. And this is about Clements versus Dart and North Dakota, and it has to do with the county, Cook County Sheriff provided a wheelchair user with an inaccessible cell. But what the sheriff office said was, hey, you know, you will have access. All you have to do is just call the nurse, call one of us. You will have access. This went to court, and the ruling, I think, was rather clear. And it basically said that this was not equivalent access, that Title II requires affirmative proactive accommodations necessary to ensure meaningful access to public services and programs, not accommodation upon request. All right, let's go to the next page, which is page 14. Policy modification. This is where I find institutions have a lot of challenges, is policy modification. And it can be known as rule modification too. And so we do know that correctional institutions must make reasonable modifications in policies, practices, and procedures, which of course can include accommodations, when necessary to avoid discrimination by affording goods and services to a person with a disability unless it would fundamentally alter the nature and goods and services provided. But if fundamental alteration is going to occur, the entity must do what they can up to the point of fundamental alteration. So the courts have actually looked at reasonable modification within the correctional setting, and they weigh the needs of the inmate with disability rights against the structural, financial, and administrative concerns of the facilities. So in particular, the courts have examined whether a modification will fundamentally alter a program or activity, and if making that modification will result in an undue financial and administrative burden. Obviously, the need for safety comes into play. That plays a significant role in determining whether a modification is reasonable. So correctional facilities do have to make modifications that do not have to make modifications that would interfere with their ability to respond to any sort of safety threat. it really is a best practice for the institution to create and implement policies that foster the staff to seek assistance from facility-based crisis intervention teams and mental health professionals, to employ de-escalation techniques, to forego discipline and provide treatment where it's apparent that an inmate's negative or disruptive behavior is related to their disability. I throw that in there because I know there's a lot of discussion going on across the nation in terms of inmates with disabilities and discipline procedures, modifying discipline rules, discipline policies around that. I think is a decision that is not going to go away, and that we all should engage in that. Clearly, the goal of disciplinary procedures is to change behaviors of the inmate. A lot of that could include isolation, segregation, and all of this can be complex. I think it's important to understand that when an inmate's disability is manifesting, if discipline is employed, that only results in not only magnifying the person's disability, causing further behavioral problems and more intense behavioral problems, but it certainly doesn't meet the correctional facility's goal of changing the inmate's behavior. Lots of discussion can happen around this. Okay. I also want to just make a little point here that in terms of discipline, it can get a little complex in that if there's an inmate that is unable to fully participate because of barriers in programs and services that awards sentence reduction credits, and so they're not able to earn those sentence reduction credits at the same rate as an able-bodied inmate. And so if discipline involves taking away those credits, that's something you have to consider, just in terms that one inmate will not have as many credits because they can't get as many credits. But of course that situation within itself has to be examined of why they're not able to earn early release credits at the same rate as other inmates. Okay, I think given the interest of time, we're going to go ahead and move forward. You can see there's some policy modification examples. Let's move on forward to page 15. And let's move down to visitor and policy modification. Again, remember, correctional institutions, make sure that you include this on your website where you have your visitor policies and rules. And so, yes, correctional institutions have to consider making modification of policies for visitation access, even if it affects visitation rules. An example may be a visitor has diabetes and they need to bring in food. Obviously, there could be concern that contraband may come into the facility that way. The facility absolutely can inspect the food. If they don't want visitors to bring in food, they might allow a visitor to purchase a commissary food item. Really, it's when you remove barriers for a visitor, it's to examine on what is the rule for, what happens if the rule is not there, and on a case-by-case basis, if you modify the rule for this particular visitor, what does that mean in terms of safety and other rules? It is also important to point out here that when the facility grants a modification of policy for a visitor, that not only the front end of visitation, that they know that that's been granted, In other words, the prisoner is allowed to bring in food. It's important that the other staff, any other staff involved in visitation on the inn, maybe in the visitation area, is fully aware that this visitor has been granted this modification of the rule. Obviously, if they're not, then interference can happen with that visitor. If they have food, they may be approached by someone who says, you can't have that. And so, therefore, you've broken the rules, therefore you must leave. And so that visitation modification policy and procedure should carry from A to Z in terms of visitors. Okay, let's go to the next page, page 16 at the top. I want to mention here, it's not listed as an example, but I know that a pretty consistent policy for visitors is that you have to wear a shoe that completely covers your foot. Let me give you an example to where a visitor may not be able to do that. If you have a disability that affects swelling in your limbs, if your feet, congestive heart failure can be one example where your feet really swell, there's just no way a person is going to get a shoe on their foot. And so this is the kind of interactive process, the interactive discussion that goes with the interactive session, which goes with the visitor, with the ADA coordinator. That it's a case-by-case basis. You have a visitor who cannot wear shoes. It's very clear that their feet are swollen. And you need to go from there to remove barriers where the person can do their visitation. Okay, let's look at effective communication on page 16. The correctional facility must provide inmates with communication-related disabilities, an effective means through auxiliary aids and services to receive and understand information and be able to communicate with others in any and all relevant aspects of facility living. This effective communication requirement obviously also applies to visitors. Just note the primary consideration, which is underlined there, that the institution must give a thoughtful consideration of the inmate or the visitor. What they're telling you is effective communication for them, what they're telling you in terms of what they need in auxiliary aids and services. A note here, if you go down a little bit farther, where it says on page 16, for example, passing notes back and forth in a medical exam for someone who's culturally deaf, I can probably pretty well tell you is not going to be an effective means of communication, and that person is most likely going to need a qualified sign language interpreter. As you can see, there are examples of auxiliary aids and services. Let's turn to page 17, the very next page. The guide talks about how you assess what type of auxiliary aids or service that needs to be used, the analysis. In the next paragraph, I just want to point out that auxiliary and services should absolutely be provided to the inmate during orientation, obviously because that's when they are introduced, that's when they learn about sanctions, mail, visiting, grievance, eligibility requirements for programs, how to participate, medical health, et cetera, and to not have that effective communication, whether you're a visitor who's deaf, or a visitor who has low vision, or is blind, or a visitor with an intellectual disability that may need a little more in communication of what all of this means, that's all effective communication and absolutely should take place. Okay, let's go ahead in the interest of time. Let's go to the next page, page 18. towards the bottom where it says effective communication examples for visitors, above that are effective communication examples for inmates. So in effective communication example for visitors, providing a quiet place of visitation so a hard of hearing visitor is able to communicate. Having amplification device in a visitation booth telephone. There is a new trend now where people with hearing aids, they use apps on their cell phones that tie into their hearing aid and does all sorts of unique and specialized things for that person to hear. It's not unusual that cell phones are not allowed in the visitation area. Again, it's important that the institution understands and sees that they have this rule, but on a case-by-case basis, they look at, can they modify that? Can they allow the cell phone? If they do, under what conditions? If they cannot, what can they do in terms of removing that barrier? You'll see there what a qualified sign language interpreter is, but we're going to move forward to page 19. We do know that the financial responsibility of providing auxiliary aids and services is the institution's. Let's go on down to the bottom of page 19, the United States versus South Carolina Department of Corrections. I'm not going to go through this extensive settlement with South Carolina's Department of Corrections with the Department of Justice, but it is a good read. It is an interesting read, and I highly recommend that you see in terms of what's expected of an institution. Let's go to the next page, page 20, and we're going to the bottom, other general requirements. I just want to point out here that there is no discrimination through contract. So whether that's a private prison contracting with a government entity or the institution is contracting with providers of any sort, that these contractors must carry out the institution's Title II and Section 504 responsibilities. Let's go to the next page, which is page 21. Personal services and devices. Generally under Title II, a Title II entity is not required to provide personal devices or services. However, obviously in the case of inmates, that has to be provided, and it should just be noted that these services and devices should be tailored as best as possible to the individual's need. Personal care attendants. I just want to point out here that the ACA deals with that, and it's important to see what they have to say about that. In terms of service animals, the facility can identify and incorporate these situations in the visitor process. Let's go into next page, page 22. And here covers all of what the ADA says about service animals and how to comply with that. Let's go to the next page, 23. There's more about service animals, so you can see that this section is quite extensive in terms of visitors with service animals and even the consideration of the use of service animals for inmates. That's all there. At the bottom of page 23 is mobility devices and other power-driven mobility devices. The Department of Justice recognizes that people may use devices other than devices that are built for people with disabilities, such as Segways. Not going to go into this because we are almost out of time, but let's scroll to page 24, the very next page. You'll see that the Department of Justice has very good guidance with that, and there's a link to that guidance. As we go down, you see common access complaint by visitors and inmates. I put it at the end of the guide purposely so that as you're training the staff, when you come to this part, then the trainees can actually read through this and can identify where the ADA violations have occurred, such as, oh, there should have been a modification of policy, or effective communication, or there's a lack of program access. Let's go to page 25 and to the conclusion. So clearly, correctional facilities have a clear and legal requirements that protect the civil rights of inmates and facility visitors with disabilities. The American Correctional Association and Commission on Accreditation for Corrections, the ACA, clearly states that discrimination on the basis of disability is prohibited, and that inmates must have access to appropriately trained and qualified persons who have the authority to assure ADA compliance of civil rights protection. The ACA performance-based standards includes procedures and practices that assure inmates with disabilities are treated fairly and have equal opportunity in all aspects of prison life. Correction facilities have a clear ADA obligations to assure that visitors with disabilities can gain equal access of that of a non-disabled visitor, including participation in any services and programs that include visitors. Facilities must assure these visitors access through policy modification, effective communication, and physical barrier removal. On the very last page, page 26, there are the resources that I encourage you to take advantage of. That concludes my presentation, Caleb.
Okay, thank you, Julie. It's a very impressive guide, and we really appreciate you sharing it with us. So we're going to move to the Q&A for our session. And we have quite a few questions so far. If anyone else has questions or comments you want to make, just type them into the chat box. So let's start with this one. If an inmate is hard of hearing, but their family is deaf, is the correctional facility, specifically a federal prison, required to install a video phone so that the inmate can adequately communicate with their deaf family members?
Thank you, Caleb. You know, that as you read the guide, and I skipped part of this, video phones are becoming more and more part of litigation. What it really comes down to is effective communication. As an inmate who's hard of hearing or deaf, I get to communicate through phone just like any other inmate. And video phones may absolutely be the effective way for that to happen. There are many out there that are arguing that video phones indeed are the only way to provide that effective communication. So when you look at the effective communication section of the guide, you'll see that there. Again, the onus on the institution is effective communication. Barring an undue financial and administrative burden, keep in mind that an undue financial and administrative burden is a fairly high bar. Next question.
Okay, next question we have is an appeal process the same as a grievance process?
The appeal process should be part of the grievance process. And so for the ADA grievance process, an inmate or a visitor should be able to identify in a easy, accessible, simple way to say, I think this has happened to me. I think it violates my ADA rights. That process should be addressed in a prompt and equitable manner as required under the ADA. And then part of that is then, of course, the institution will make a decision of whether or not civil rights have been violated. Part of that process, if the decision is not made in favor of the inmate or the visitor, yes, there should be a higher appeal process to where there's another opportunity to express their case. So that should be inclusive of the grievance process. I hope that answered the question.
All right, here's our next question. We have a visitor who said he needed his cell phone during visitation because the phone has a hearing aid application that interacts with his hearing aids. Do we have to allow this?
Right. As I mentioned earlier, that's the new thing. Cell phones are bringing all sorts of wonderful access for people with disabilities. And so it may be hearing aids today, but it could be something else tomorrow. So I think it is important for institutions, for correctional institutions, to start taking notice of the cell phone and what the cell phone can do for people with various disabilities. Having said that, I can't give you a yes or no answer. What the answer I can give you is you need to do the analysis. You need to do the analysis of a modification of policy and effective communication. So you have kind of a dual analysis there. The modification of policy of normally we do not allow cell phones in the visitation area. However, this is an assistive device for this person who has a hearing aid, like assistive device of a wheelchair or assistive device of a hearing aid. It is an assistive device for this person. And so bring in your ADA coordinator and really talk about why do we not allow cell phones, and those reasons are clear. So on this case by case, on this individual case, if we allow this person the cell phone, can we in some way mitigate to where we're not going to have a problem with the cell phone, etc. So I can't really tell you yes or no, but what I can tell you is to really put forth a good faith effort in recognizing that this phone is an assistive device for this person, have the interactive process with this person, exactly how that works for them, have a discussion with them why phones are generally not allowed, and together figure out how you can make it happen. And I realize when I say this, this is not necessarily an easy process, but it is a process in which you need to do. If you, in the end, decide that allowing a cell phone in is going to create a honest-to-goodness direct threat, is going to break other rules that will create a threat, will be a safety problem, etc., then the next step is to figure out, okay, what can you do? Can the visitation in some way be a little better supervised, etc.? So you can't just say, well, nope, no phones, not allowed, can't do, sorry. You have to go through that whole process and then in the end figure out what you really can do and do it, and it's called a good faith effort. I hope that was helpful.
Okay, thank you, Julie. Next question here. This person says, is there a time limit for prison institutions to acknowledge and provide needed care for inmates' request for medical reasonable accommodation? If needed care is not provided, what recourse does the inmate have, especially when they are in an acute stage of suffering and or medical emergency?
Okay, so let me say first of all, in terms of medical care, some of that goes beyond the ADA in that I know that there are correctional standards as well as other laws that are going to come into play here. Okay, I can only address the ADA in Section 504. What the ADA says is that accommodations need to be provided in a reasonable amount of time. Believe it or not, the term reasonable is a legal term. It's frustrating for some people because, well, what does that mean? And I think it's when you have a reasonable person looking at medical services are needed here, the person needing these services, the inmate needing these services, needs access to these services. So a modification of rule, a policy, rule, practice may need to happen to remove a barrier. Effective communication may need to happen to assure, auxiliary aids or services may need to happen to assure. And so the best practice is the facility anticipates this, especially around medical care. So it's not a big surprise when an inmate who's deaf needs an interpreter. And it's to be anticipated, as the court talked about, as I talked about earlier in one of the court decisions. And so if you have a lean, clean request machine, so to speak, that needs to be immediately enacted. The prison does need to, and this is why, to pay attention, to respond. That's why it's important to have an ADA coordinator that is not going in 100 directions on issues other than the ADA, that you actually have a system in place that can be efficient and address. Reasonable amount of time, that if someone is suffering, a reasonable person would see that the person needs pretty much immediate medical attention and they can do what they need to do. So depending on the type of effective communication, if it is someone in this case who's deaf, you may need to get an interpreter, you may need to get video remote interpreting, etc. So it's working with groups, disability-related groups in the community as well as your ADA centers, and how do you set that up where response times can be assured and can be reasonable. Next question.
Okay, this person is asking, are inmates allowed to have a mobility cane if they are blind or visually impaired and needed for mobility? I've been told that canes are seen as weapons and therefore are not allowed.
Yeah, and that has been a discussion throughout the nation. Any kind of assistive device that can be used as a weapon, of course, correctional facilities are adverse to. Again, the frustration and the beauty of the ADA is it's a double-edged sword. One end doesn't say you have to no matter what. The other end says you have to go through the analysis. So if you have someone who needs a cane for mobility travel, you have to look at that particular case, that particular environment, and you have to make some modification of policy decisions around that. You have to weigh off that the person has to navigate versus that the person will maybe use the accommodation as a weapon. Clearly, you don't have to modify a policy, or you can rescind the modification of policy if an assistive device in some sort is used in an inappropriate way. That would not be a reasonable modification. So I want to acknowledge that I know there is struggle out there in terms of weighing off prison safety versus creating an accessible environment for inmates, but you got to do it. And you have to do it in a good faith effort. If you determine that the cane is going to be used, is a direct threat, the person is going to be a direct threat, a significant harm to the safety of others, you don't have to provide it, but you don't not do anything. Then you have to figure out, okay, the inmate has to have the ability to be mobile throughout the facility. Again, and I know I have said this several times, so forgive me, but it is important that people with disabilities have all kinds of answers. Organizations that serve people with disabilities, organizations that are run by people with disabilities, I encourage you to reach out to them so that these discussions can be had and solutions can be sought. Next question.
The next question is, do specific video phone providers or vendors need to be used so that security and constraints may be applied as with any other prisoner and that calls may be recorded? For video phone, I am not qualified to answer that. And so in terms of the video phone usage, you'll need to seek an answer from someone who knows a whole lot more about video phone
interpreting and those systems. You may have, here in New Mexico, even though the Southwest ADA Center, our office is located in Houston, Texas, I'm located here in New Mexico, and we have a commission for the deaf and hard of hearing. I think almost all states do have a governor's commission on disability. A lot of local government have city commissions on disability, and so Centers for Independent Living, so I would encourage you to turn to those resources in terms of exactly how do these phones work and how can we implement what we need to around those phones to assure what we need to make happen. Okay, next question.
Hold on one second. I'm just reading this one here. This one says, Capitol phones have numerous security issues for prisons. Are these mandated for hard of hearing populations? I know you said you're not an expert on this, Julie, so maybe you don't know the answer.
Yeah, again, I think it's important when you have specific questions about specific disabilities and access for someone with specific disabilities, which could look different. I mean, I may have the same disability as somebody else, but my access, my barrier removal may look different. I cannot stress enough, go to the resources who know these things. Go to your Centers for Independent Living. Go to your Governor's Commission on Disability. Go to medical professionals. Go to people who actually have the disability. It's remarkable what you can learn in terms of removing barriers. And if you go and you learn how to remove barriers, you are so much farther ahead that when you have the visitor with a modification request, or you have the inmate with the modification of policy request, or the effective communication, or the accommodation request, you're far ahead of the game because you have highly educated yourself in terms of what barriers do lie within prisons, what kind of barriers an individual with certain disabilities will encounter. You have the interactive process with that individual, and you'll be far ahead of the game.
Okay, I've got a couple questions here that are asking about what inmates can do if they don't think their rights are being respected. Let me just read one of these comments here. This person says that at Alabama institutions, eyeglasses are not considered assistive devices by medical, and they deny all requests for accommodations. Nothing we say does any good. I saw another comment too that was asking about what can an inmate do to file a complaint. Are they able to file complaints?
Under the ADA, they should be able to file an ADA complaint. When we went through that every institution must have a grievance process, that means every institution must have an ADA grievance process. If there's not an ADA grievance process, you have the Department of Justice or a private lawsuit. I do recognize that with the Prison Litigation Act, there are some restrictions around that. Just in terms of inmate being able to just simply talk to legal counsel and have access to legal counsel to find out what they need to do. If the ADA is not being implemented, that's a problem. It is important for advocacy organizations to be on alert and aware when correctional institutions are not complying. They are not providing avenues for an ADA grievance process, or the grievance process is not complying with the ADA requirements. I wish I had an answer that will solve all. It just really comes down to, we live in a society in which we highly value civil rights. That includes correctional facilities of inmates and visitors to those facilities. There are other laws in place to hopefully assure that. And I know I'm not giving you quite probably the answer you're looking for. The only answer I can give you, that I'm qualified to give you, is that the institution has to comply with the ADA. They have to comply with Section 504. And if they're not, that inmate or their family needs to use any means that they possibly can to bring that to attention.
We have someone who is questioning something you said earlier. They say an offender that works, or that an offender that is ADA can work 6 hours, and we have to give them 8-hour pay? Question mark. I think this is a skeptical response.
Right, and understandably so, because that does make sense. You know, if you work 8 hours, you get 8-hour pay. You know, whether that's $1 an hour or $3 a day or whatever that is, you work the 8 hours. If you work 6 hours, you should get what is equivalent to the 6 hours. The reason I brought that up is to really stimulate in terms of thinking about your program, services, and activities, thinking about how you make them accessible. In the ideal world, you would have an 8-hour day, and you would design the program in a way that if I can only do 6 hours physically due to disability, you give me 2 more hours that I can do that's not so physical, which then gives me the 8-hour days. If you're not able to do that, if the inmate has some sort of severe disability that they cannot do an 8-hour day, then what other programs do you have that are equivalent that they can do? And how you measure that, and how then you measure like the sentence reduction credits and how those are dispersed. Really, it's stepping back and looking at the whole picture. It's stepping back and saying, in a nutshell, let me share with you in a nutshell. ADA basically can be summed up in a sentence that says, I get to do what you get to do most of the time, but not always. And so when programs are not accessible to various inmates with disabilities, they serve longer sentences because they can't have the opportunity of sentence reduction credits. They can live within a prison within a prison because they don't have effective communication, or they're disciplined in a way that only exasperates their disability, etc. So it's standing back and saying, okay, what services and programs do we have at this facility? How can we incorporate our inmates with disabilities into these programs? How can we assure that these inmates have opportunities to fully and equally benefit from these programs? In your full analysis, if you come down to where you have a particular inmate that can put in a 4-hour day, but due to disability, they just can't put in an 8-hour day, the prison needs to step back and look at that. Why do you have that program? What does it mean to participate in that program? If an inmate is cooperative, they work hard at it, they show incentive and motive, why do you have that program? What are you trying to measure? What do you want to see happen with that inmate? You want to see initiative. You want to see cooperation. You want to see that they want to work. You want to see they want to be reformed, so to speak. And so when you look at it from the macro and then you come into the micro, then you make decisions that just because I'm an inmate with a disability, I should not in any way be penalized in benefiting from those programs. Now, how you come to the conclusion of creating that equality is how you come to the conclusion and implement those conclusions of equality. So the bottom line is equality. So I brought that up earlier because it does stimulate conversation. And hopefully whatever conclusion you come to, you're promoting equality of benefit.
Our next question is, this person says, most accommodations are documented by medical exams and diagnoses, but learning disabilities may be documented only by other types of professionals that cost a lot of money. Do you have suggestions for how to fund when a staff member suspects a learning disability, especially when LD may be negatively impacting progress in education services?
I wish I did, because the question is very specific of how to fund, and I'm not in a position to have that discussion. I totally get it, though. Resources are limited. They're and correctional institutions by no means are an exception to limited resources. In terms of looking at that, I'm trying to think how to put this. Highly suspect an inmate has a learning disability. You see it. Staff that spend lots of time with inmates see lots of things about the inmates. And so you may see difficulty in reading, you may see difficulty in writing, you may see that they have great difficulty in understanding. You may see if you talk too fast, it doesn't work. That's important to at least have those observations, which of course then leads you to testing. If it's an undue financial administrative burden, I think it's important to not just go, oh well, we couldn't test, so therefore it doesn't exist. I think it is important to say, you know, something's happening here. The medical staff or contractors see that something's happening here. The prison staff sees something's happening there, and you have to acknowledge it, and you have to do what you can to remove those barriers. I think it is important that state legislators, as they fund correctional systems, they understand that people with disabilities, 750,000 people with disabilities are found in our correctional system, that it is important that there is funding in which civil rights are always assured. Again, as I have said earlier, that may not be quite the answer you're looking for, because the answer is, gosh, wouldn't it be great if we were all fully funded to do everything we do? Just keep in mind, however the budget is laid out, the budget has to address, there has to be consideration when the Department of Corrections is creating and implementing their budget. They have to do it with full awareness that prisoners, that inmates with disabilities have civil rights, and at times in enacting those civil rights to remove barriers costs money. I wish I had a better answer, but I understand your frustration.
Well, we're almost out of time. I think I can ask one more, and just have about a minute, Julie. This person asks, can inmates have a copy of Julie Ballinger's guide to help them understand the rights under the ADA?
The way I can answer that, Caleb, very quickly, is that this guide is for public consumption. So the intention of this guide is for, I wrote it for correctional institutions so they can take this guide and institute training from it, but this guide is public consumed. And so whatever an inmate is allowed to consume publicly, magazines, newspapers, this is a public consumption guide.
Okay, thank you very much, Julie. I know there were some questions we didn't get to, but Julie has provided her contact info. So if you want to ask her a question, you can send it directly to her. Let's go to slide 15.
For those of you who registered for a certificate of participation, refer to the webinar description for information about how to request the certificate.
Slide 16. The ADA National Network is comprised of 10 regional centers that provide guidance, training, and materials on the ADA. You can contact your regional center by calling 800-949-4232, and you can visit their website at adata.org. Slide 17. And we are the Mid-Atlantic ADA Center, a project of TransCen, Inc. You can call us again at 800-949-4232. That's the toll-free number. Or if you're local, you can call us at 301-217-0124. Our email is adainfo@transcen.org, and our website, adainfo.org. So thank you everyone for joining us today, and have a great rest of your day.